Hi, this is Rick Frederick, reviewing the case of State v. Pike, 1870. This is not a really great case to review, except for the dissent in the case, which became important in American law. The facts of the case are that Pike hit somebody with an axe during a robbery. He was drunk at the time. And he claimed at trial that this was a form of insanity because essentially he was a dipsomaniac, a person who could not help but to drink. So the judge told the jury that it was their job to decide if alcoholism or dipsomania was a disease, and also to decide whether Pike was made insane by intoxication. With respect to what you should think about a defendant is that a defendant is presumed to be sane, but when there's evidence of insanity, it was the prosecution's burden to prove sanity. So this was the jury instruction. The court accepted testimony from non-experts that Pike was an alcoholic, but rejected testimony from non-experts that Pike was insane. So this is actually pretty straightforward stuff, but things that which Pike appealed, saying that it was up to the judge to decide if alcoholism was a disease, whether it could make you insane, and so on. So the issues are not really the important part of Pike. The holding was that alcoholism, whether it's a disease, is a question of science and fact, not law. So that's up to medical specialists. This has always been a testy issue in case law, whether it's the court that decides what's a disease or whether doctors decide what a disease. Here, the appellate court says it's up to the doctors to tell us what a disease is. You can't decide insanity without experts, and it's commonly known that alcoholism is not the basis of insanity, which might be something we could question, but intoxication itself, non-experts can testify to, because we all know what intoxication looks like, essentially. Insanity, not so much. So non-experts cannot testify that the defendant appeared insane to them. And then the appellate court did say that every defendant is presumed to be sane until there is evidence to question that assumption. Now, why Pike is interesting is because of the dissenting judge, Judge Doe. And so it's interesting. This case well worth reading to just jump to the dissent and see what Doe has to say. And if you look at the case of Parsons, which is also in my playlist, you can see the development of an idea that maybe McNaughton cognitive restrictions are too restrictive. Maybe there's more to the issue of what causes people to commit crimes, alleged crimes, with respect to the presence of mental disorder than whether they actually know what's right or wrong. Is there a problem of choice or impulse control? And so what Doe suggests here is that maybe insanity is better understood as the product of a mental disorder, even if a strict cognitive test is not met. That's why Pike is in this playlist, and it's well worth reading. Again, the first part of it is not very clear, but the dissent by Doe is cited again and again. It becomes what was a standard test of insanity for many places, especially New Hampshire. Thank you very much.